Hello, I'm Locke Meredith with Legal Lines. I'd like to ask you to join us on our next show. We have Sean Fagan, my partner, on, and we're going to talk about the legal issues that are involved in the politics of today. Particularly, we're going to talk about TV morality and regulation by the federal government. We're going to talk about the United States Supreme Court. We're going to talk about same-sex marriages and all the other political issues that involve the law. So join us on the next Legal Lines. Welcome to Legal Lines. I'm Locke Meredith. Pleased to have on the show my partner, Sean Fagan. We're going to talk to you today about basically the big issues in politics and the presidential election and how it deals with the law. They kind of intermingle pretty significantly. Sean, thanks for being on the show.
Hello.
Let's talk about first this same-sex gay marriage issue. As you know, we've got a situation where we've got some mayors who are marrying same-sex couples. And then we've got a Massachusetts Supreme Court rendering a decision that under their state constitution, not the federal constitution, United States Constitution, but their state constitution, that constitution requires a marriage be permitted between folks of the same sex. All right? So let's talk about the legal ramifications. First of all, these guys, these mayors doing this. What's your spin on it?
Well, what we've got is the mayor is obviously the president of the smallest political subdivision in the state, which is the city, parish, or county. And generally, it's a city. We've got mayors in San Francisco all the way to Maine that are marrying people that are same-sex folks. And the mayors generally, under the state constitutions as well as state law, have the ability to perform marriage ceremonies. So that's where
although some do not. I think the guy
right.
in New York, particularly, and the attorney general there is looking at prosecuting. In fact, it filed charges. To prosecute him because he is not authorized to do marriages.
That's correct.
And so these guys are not complying with state law. They just decide, like I know the San Francisco mayor just said, I disagree. I think the interpretation of this law, though he's not a judge or a state legislator, I think the interpretation of this state law requires that I be permitted to do this. And so he's just saying, I think I'm right, everybody else is wrong, or the people who disagree with me are wrong, I'm going to do it my way. That really doesn't fly, or is not supposed to fly, in the United States.
What you've got is these are political issues that are hot-button issues that obviously right now we're seeing bring up national exposure. And so that factors into it, but certainly what it does is it creates a problem because those are the individuals that basically are executing the laws that are interpreted by the courts.
And basically saying we're above the law, or,
That's right.
or our interpretation is supreme, and they're not following what has been the delineated process of how a law is passed and how it's interpreted. And we're not passing judgment on the issue itself. We're just talking about these are folks that are basically putting themselves above the law. That's different from the Massachusetts Supreme Court saying it's our opinion. They're acting in their role granted to them by the state constitution. They're saying we're interpreting our state constitution as requiring same-sex marriage. Otherwise, you're violating equality clauses. That's a big difference than these guys over here doing what they think's right, because these guys aren't authorized, these mayors aren't, but this state Supreme Court is. Let's talk about the distinction.
It makes for an interesting situation because actually anybody can come in and challenge the a state statute, law, or constitutional provision and say that their interpretation is different. What happened in Massachusetts, of course, is the Supreme Court weighed in and said that under the Massachusetts Constitution, the laws or the provisions regarding marriage are gender neutral, and that allows the same-sex marriage issues to unfold there. What's happening in San Francisco and New York and Maine and some of the other states where this is occurring is people are basically challenging it, and it's coming through the mayors. What's interesting about it is, of course, in California, the courts have been asked to step in and stop it on a via preliminary injunction, which means it stops it right now, and then they figure out all the legal issues down the road. The courts have declined doing that. In fact, the Supreme Court, I believe, right now is waiting for briefs on the issue.
The United States Supreme Court.
Actually, the California Supreme Court is waiting to decide that issue. But of course, what the next issue we were discussing before we began taping was, well, how does this implicate the United States Constitution and each individual state's rights to decide
what we have right
what is marriage.
Is Senator Kerry, who's running for president, is saying, I think the way we resolve this is we let the states decide. And as I understand it, President Bush's position is we can't let the states decide because they don't really get a chance to decide because we have a state Supreme Court saying this is the law of the land.
Mm-hmm.
And under our United States Constitution, there's a clause called full faith and credit. Mm-hmm. What does that mean?
Well, the full faith and credit clause means that if a decision is rendered by a court in one state, the other states have to give credit to that ruling. In other words, in this instance, a marriage. If marriages are allowed under the law of Maine, that marriage is given credit and full faith when that couple comes to Louisiana.
So, if I think you're good looking and I say, hey, you want to marry me, and we truck up to Massachusetts and we get married, under Massachusetts law, we're now married. And so we can say, even though Louisiana may have a law that says, we don't believe in that, we're not going to agree to it, we have a law against it, we can come down here with our marriage certificate from Massachusetts and say, you have to recognize our marriage, Louisiana, even though you got laws against it, because the United States Constitution requires that your state recognize Massachusetts state's authority in the decision in this matter, correct?
That's right. In other words, the United States Constitution trumps everything else. And so if any particular state's constitution has a provision in it that's inconsistent or contradicts what's in the U.S. Constitution, the state constitution falls.
And so when Senator Kerry says we believe it's the state's right, we're not going to support a United States constitutional amendment, really what he's saying is, or what he's not dealing with, is this issue of the full faith and credit clause. Because in essence, if you do not deal with this in the Constitution, Louisiana is going to have to recognize that Massachusetts marriage, isn't it?
That's where it's leading.
And that is why, as I understand it, President Bush is saying, look, I want states to be able to decide this, but the only way to do that is to have a constitutional amendment that defines marriage as being a marriage between a man and woman, and I will support, as I understand it, civil unions, which is the ability for every single of the 50 states to define what a civil union is and what rights are granted by that.
That's right. In other words, it allows the states to make a distinction between marriage and civil unions. And any individual state that might feel that marriage is only just designed to be between a man and a woman, those states can maintain that position, but then write separate laws regarding civil unions and what rights and privileges may come with civil unions.
And so in this scenario, Massachusetts, because the United States Constitution would be amended if President Bush's action is taken, would define marriage as between a man and woman, but Massachusetts then could not say we're going to have same-sex marriage, but we will have a civil union that conveys, in essence, all of the same rights, or however the state decides to determine those rights, and those rights would be recognized by all the other states at that point.
Well, the important thing is that it potentially allows each individual state to write its own provisions regarding what civil unions, what rights would be allowed within the borders of that state with respect to civil unions, which means really Massachusetts could say within our borders, if you are a party to a civil union, we will afford you these particular rights.
Delineated, outlined.
And the same rights may be different when they go to another state.
Okay. All right, what we're going to talk about on the next segment is the other political issues that involve the law. This is The Legal Lines with Locke Meredith and Sean Fagan. We'll be right back. Welcome back to Legal Lines. I'm Locke Meredith. I have on the show today Sean Fagan, my partner, and we're talking about legal issues that are involved in the big political scene right now. Sean, we were talking about gay marriages or same-sex marriages and the difference between the full faith and credit analysis and allowing states to decide. And one issue probably we did not properly address is what is the difference between a marriage and a civil union?
Right now we don't know. That's what's coming down the road. All of this talk and litigation and at least potential litigation that may come up is designed to really decide, number one, whether or not marriage is between a man and a woman. If the state constitutions, the federal constitutions reflect that it's between a man and a woman, the next issue is, can there be a union between same gender? And what is the nature of that union? They're describing that now as a civil union, but that has not been defined by any of the states as far as I know.
Bottom line is marriage has been defined. Every state has laws that deal with marriage. and it delineates the rights and obligations between each other, and if they have children, the rights and obligations, and if they acquire property or debt, the rights and obligations. Marriage is a contract at this point in time, at least up until this point in time, between a man and a woman, and their relationship and the assets and the liabilities is all regulated by law in every single state. What folks are talking about is a civil union, which, as I appreciate it, is going to probably mimic or replicate all of the regulations of a marriage, but it's not going to be called a marriage because a civil union will allow a union between individuals of the same sex. But we don't know for a fact what a civil union or how a civil union will be defined, because every single state will be able to define it as they deem appropriate. Some states may say, see articles such and such in the code that deal with marriage, and now civil union has basically been defined as marriage, granting all the same rights. On the other hand, it may say that you can own property together, but if you split up, it doesn't deal with it the same way as marriage. It may not define it the same.
That's right. Marriage is exactly what you said. It's a civil contract that the law recognizes and inserts certain provisions into that contract. These are the rights and these are the obligations that you have. When they create a definition for civil union, you're going to have similar things go on, but the rights and privileges in that contract that the state puts in may not be the same as marriage. And that's where the difference will be among the different states.
Let's talk about another political issue that involves a law that's bouncing around or has bounced around in the past, and I assume it's not going away. And that is the issue of separation of church and state, that is religion, churches, faith, and government. And the fact that we had this collision between the two in Alabama with Judge Moore and the Ten Commandments statute that he had in his facility. Outline the facts. I know everybody probably knows that.
Yeah, basically what happened was Justice Moore was the Chief Justice of the Alabama Supreme Court, and he elected to have a statue or a monument of which had the Ten Commandments written on or inscribed on the monument.
In fact, ran on that platform.
Yeah.
When I get there, this is what I'm going to do, and was elected.
He was elected by the people by a popular vote. He goes in, fulfills his campaign promise, puts in a monument that has the Ten Commandments inscribed on it, and shortly after it was placed into the governmental building, because it was placed in a governmental building, that's what the issue was. And shortly after it was placed in the governmental building, someone challenged it and said that violates the separation between church and state.
And of course, the challenge was not in the state courts. The challenge was in the federal court.
That's correct, and that's where we get back to what we were talking about earlier, the tension between the state constitution, which governs everything within the borders of the particular state, and the United States Constitution, which trumps that and governs is the law of the land.
The nation, the United States of America. And so a federal court judge, when he received this lawsuit that says, hey, they're doing something in the state of Alabama that violates separation of church and state, this federal judge did what?
The federal judge said, I can hear this case even though it involves an Alabama Supreme Court justice, because the justice's action may be in violation of the federal Constitution, and because the federal courts have the jurisdiction over the United States Constitution, they can make a decision that could be binding on the state court.
The bottom line is what we have little parish laws, in essence, state laws, and then federal court laws. And federal court laws are up here and everything else is below. And if there's a conflict between these laws below the federal law wins.
That's right.
And this federal judge said what?
Federal judge said, under the United States Constitution, Alabama, you cannot, even if your Constitution says you can, even if the Alabama Constitution says that you can do this, the federal Constitution says you cannot put anything such as the Ten Commandments in a governmental building, because that separates, or rather, that violates the U.S. Constitution's provision on keeping church separate from state.
What's interesting is, and I've had Judge Downing, who's First Circuit Court of Appeal judge here in Louisiana, talk about this. And there are all ways that you can post the Ten Commandments and other faith items, but it has to be in a supportive way. In other words, it has to be more historical in nature.
That's correct.
That wasn't done in this case.
That's right. And it was,
I guess that's what the federal judge found.
What Judge Downing has talked about in the past is that it would be possibly a different scenario if you put in maybe the Quran and some various other religious articles and artifacts along with the Ten Commandments. That didn't occur, and it stood out, and that's where the challenge came from.
What's interesting, as I understand the history of our United States Constitution, is that in the beginning, the people had all of the power and all of the rights, and the states, and via the people, conferred upon the federal government the rights and regulations and powers that they now have. And that Justice Moore's position was, look, we have the power to define separation of church and state, and our state constitution allows this to take place. We never gave you the power, federal judge, to tell us that we couldn't do this. But that's not the way it went down, is it? At least so far.
In recent years, you've kind of seen a reverse of what the Constitution was originally intended to do. When it was originally drafted, the idea was that the United States Constitution would define exactly what the powers of the federal government would be. If it wasn't contained in the documents, it was not a power of the federal government. Everything that was not contained within those documents was ceded to the states, which means that...
Because the states gave them the right?
That's right. That's right. It was a document that said that this is it, everything else is yours. And what Justice Moore was saying was, look, the Constitution does provide for the separation of church and state, but it does not say exactly what that separation is. The separation may be defined by the individual states.
And the federal judge said, no, I define it.
That's correct.
And of course and the interesting thing is, and this is, I guess, where a lot of collision between positions occur, is if there's not express language dealing with the particular factual situation, the judges are required to interpret the facts in light of what they do have, and they have, in essence, expanded the power of the federal government over the last 200 years, so that now we're in a position where the federal government basically has all the power, at least most of the power, at least that's supreme to the state.
Sure. I mean, one of the examples you see more often is when the federal government provides money to the states to do work.
And they yank it if you don't do it the way they want.
That's right.
All right. Next segment, we're going to talk about TV morality in the law with Janice Jackson and that whole bit. It's Legal Lines with Locke Meredith. Sean Fagan will be right back. Welcome back to Legal Lines. I'm Locke Meredith with Sean Fagan, my partner, and we're going to talk about TV morality, the regulation of TV versus freedom of speech, and the difference between broadcast television and cable. Sean, let's talk about that. Everybody's familiar with the Super Bowl thing, and I heard recently some rantings of Howard Stern because apparently his plug's been yanked because of stuff that he did on his show. Let's talk about kind of the tension between regulation of the freedom of speech, in essence, and the morality issue.
Well, that's where it starts, is the freedom of speech under the U.S. Constitution. What happens is the Congress has the right under the United States Constitution to enact laws that define what is free speech. And there's a difference between regular speech between you and I and what's called commercial speech. Well, what's happened over the years is as televisions come up and radios come up, the Congress has created the Federal Communications Board, which is the FCC, everyone knows it as. The FCC has rules and says what a broadcast station can and cannot do. Of course, the difference is what is broadcast and what is not broadcast.
I was going to say, let's distinguish between broadcast and cable, because apparently it's quite significant.
But because the broadcast channels are ones that are broadcast across the airwaves
and regulated more extensively by the federal government,
and that's why, because it's a broadcast medium, meaning they can be picked up by anybody who has a television set with an antenna on it. It's very closely regulated. That's in contrast to cable, which is a media that you can only get hold of if you pay something for it.
Or would you ask for it? You say, I want it, I'm going to pay something for it, send it to my house. And that's a difference between just turning on your TV and you have access to a broadcast versus the cable. You pay for it, you ask for it, you get it. You get what you want, or you get what you ask for.
That's right.
And apparently, though, and of course, cable TV is regulated, but not in the same way that broadcast TV is regulated.
That's right. Much closer scrutiny on broadcast TV.
And as I understand it, the major cable networks recently adopted apparently some more conservative positions as it related to the material that's allowed to be broadcast, and Mr. Stern's show was yanked.
That's right.
And so there, the action of the cable company is not being mandated by the federal government. Government isn't coming in and saying, you're showing some stuff on your TV, channel I don't think you should be showing, take it off. Here, what they did is they responded basically to commercial pressures or people saying, we don't like it, cut it out.
Because in Howard Stern's case, he had two things going on. One, his show is broadcast across the radio waves, and then he also has a video segment that goes on one of the cable channels. And what he can show and do on the cable channel is vastly different than what he can do when it's being broadcast over the airwaves. And so that's where the problem comes up. And there's been self-regulation within the cable industry. But the interesting thing is the Super Bowl deal with Janet Jackson, had that occurred on a cable channel,
then okay.
Wouldn't have been a problem for the FCC.
The FCC wouldn't have done it.
That's right. They would not have had the same rights to come in and fine and impose other penalties on the network, because if it was a non-broadcast cable channel such as ESPN, those same rules and regulations may not apply to them.
We've talked about in this show the gay marriage, regulation of morality, and other issues of law that are involved in politics right now. What's interesting is that when it's all said and done, what we have is a few folks sitting up in a big white building in Washington, D.C., meaning the United States Supreme Court, deciding what's going to happen for millions and millions of people in the United States. Let's talk about that.
I guess what's frustrating for me personally is that the folks that are there, and whether they be in Washington, D.C., or whether they be in the state legislatures, we elect them. And what's occurring now with greater and greater frequency is people are just getting sick of it. And fewer people are voting, which means that the folks that are being elected are people a lot of times that don't reflect the population as a whole. They reflect a very small group of people who really get out the vote. And to the degree that we see things changing in the federal government and the state government, if we don't become actively involved and we don't vote, we really only have ourselves to blame. But that's exactly what's going down.
Let's talk about the distinction, because you said, we've got the state representatives, the state senators, we have the United States representatives, United States senators, the governor, the president. All these folks in the executive and legislative branches, for the most part, are elected by the public.
That's right.
And some, at least in the state, at the state level, we have the state judges in the judiciary. They're elected. Our judges in the parish and in the state are elected. Even our Supreme Court in Louisiana is elected. They're accountable. If the people don't like what their state reps or senators or judges do, they can vote them out of office next time they come up. Guess what? In the federal government, the judiciary, the judges, are appointed by, they're selected by the president, and they have to be confirmed by the Senate, and they're there for life.
That's right.
They're not elected, and they can't be removed unless they really do some bad stuff and it has nothing to do with decisions. They're there until they die or until they resign, and they're not accountable to the public at all, or even the people who appoint them.
That's right.
And put them in office. That's kind of scary when you think about this as being a, quote, democratic society.
It's got, the idea behind it makes a lot of sense, that you want the judiciary, who's out there interpreting mainly the U.S. Constitution, and again, we're talking about the federal judiciary there, at least at this juncture. You want them to not be afraid to do what is right and what they feel is a proper interpretation, for fear they're going to lose their jobs. But the problem is, we go back to the folks that are selecting these judges, that we want those judges to reflect really what the overall community or the country stands for as a whole. And when they're not accountable, when they're not subject to removal really, except for something that's very flagrant and very extreme, you get people up there that might be just have partisan views, and they're not voting or making rulings or judgments based on really what the law is. They're doing it just based on what their agenda may be.
You worked for United States Virginia Senator Treble, and you saw politics on a day-to-day basis, and the whole concept was, look, we want our federal judges not to be subject to politics. And maybe in the beginning that's the way it was. The president would select one. Pretty much every time the Senate confirmed it, there were no litmus tests for how had they voted in the past and all that, and they were appointed. Not a very political process. Today, it's not that way at all. They fight tooth and nail over selections made by both Democratic and Republican presidents. It's incredible. It's an extremely political process now.
It's resulting in gridlock. And you have courts across the country that are aching for new judges because the load on the court system is significant. You have judges retire, you have judges resign, and they can't fill the spots because of the gridlock up in Washington.
And this shows the absolute importance of the next election because we've got several Supreme Court justices that are probably going to retire in the next term. And of course we have a lot of split decisions, and this is going to be quite a turn coming up. Sean, thanks for being on the show. This is Locke Meredith with Legal Lines. We'll see you next time.